Good morning and welcome. Thank you for joining us this Saturday morning. If you have not been outside, it's a little brisk for a almost fall morning day, but it's supposed to go into the low 70s. So I promise you, by the time it's in the 70s, you will not be on this webinar. We will be done shortly. All right. So just a few housekeeping issues. Many of you already know who I am, but I just wanted to go over a couple of things. My intent is not to make this presentation long by any stretch of the imagination. I'm going to provide a general overview of what your roles are as fiduciaries, as well as your duties and responsibilities. This presentation is not intended to be an end-all and be-all. There will be some time at the end for Q&A. If you have some immediate questions, then go ahead and put them into the Q&A section, and depending on what they're okay, sorry, the volume is good now. Okay. Depending on what the topic is, my staff may answer it. Brianna Reed and Angela Galaveras, some of you already know who they are on this call, and so they'll also be monitoring the Q&A and the chat if anything needs to be done. As your questions come up, put them in there, and I'll try to get to them either as I'm going along, but definitely there's a section at the end for us to do that. Now, it's important to know I will not be able to answer personal or client-specific questions due to confidentiality reasons. But if you stay to the end of the presentation, you'll see how those particular personal questions can be addressed. Next, this presentation is being recorded and will be made available to you for review. However, the slides are not something I'm going to be handing out, but it'll be all part of the presentation. So without any further ado, and I don't think any other housekeeping issues, let's go. So the first thing is, what is a fiduciary? A fiduciary is someone who manages money or property for someone else. When you're named a fiduciary and you accept the role, you must, by law, manage a person's care, their money and property for their benefit, exclusively, not for your benefit. There are three potential roles that you have as a fiduciary. One is an attorney in fact. The other is a personal representative, or as you probably heard more popularly, it's called an administrator or an executor. And the last one is a trustee or successor trustee, which actually requires the creation of a trust. Personal representative, in your case, it'll be if you're named as a personal representative, but it's something that goes through probate. Okay, so let's start off with the attorney in fact. For most people, the phrase power of attorney means very little to them. Even for those educated on the subject, it's easy to forget exactly who serves what role and why. So to start, it helps to understand what is being asked of someone under a power of attorney. A person appointed to the role of attorney in fact becomes a legal representative of the principal. So who's the principal? Well, that's the person entrusting you with their care, their money, and their property. In effect, the principal is giving you permission to step into their shoes and act on their behalf. Now, just a quick distinction between attorney in fact and someone like me. I'm an attorney because I'm an officer of the court granted by the law. That's why I'm referred to as an attorney at law. I've actually passed the bar. The court has said, of the jurisdiction of Maryland and D.C., has said, we bless you to execute the laws and to represent people in this jurisdiction. Whereas if in your circumstance, your agent was given the power by the fact that you appointed them. So that's why they're called attorney in fact. I hope I didn't make that more confusing, but there's a distinction between attorney in law and attorney in fact. Often when I'm doing the power of attorneys, people say, okay, if they're my attorney in fact, then who are you? And I have to go through that explanation. All right? Okay. So for those appointed under a limited power of attorney, though, the agent's power is very, very specific. Remember, the other one is a durable general power of attorney. It covers everything with some exceptions. But a limited power of attorney limits the ability to act on behalf of the principal, right, to a specific transaction or actions outlined in the document, such as executing a deed on behalf of someone who's out of town. This kind of power of attorney includes stricter parameters for what the agent can do on behalf of the principal. An agent under a general power of attorney, though, has the authority to conduct all financial business on on behalf of the principal, subject to any restrictions that were enumerated in the document or by state law. So, for example, particularly in DC, there's a particular section that has to be checked off and language on the document to allow someone to do real estate transactions. If you add that document, they can pretty much do everything. But there's some things where you can check off and say, no, I don't want this person handling my taxes. I don't want this person handling my business affairs. I don't want this person handling my online accounts. Or you can just authorize them to do all of it. So regardless of which kind of power of attorney you have, the agent must always act as a fiduciary to the principal. All right. Now, this means that you must operate in good faith with the best interest of the principal and the principal's affairs in mind. I cannot stress that enough. All right. When making any decisions, the agent is required to consider the choice that the principal would make. Those who abuse that power in that role can be held liable, both civilly and criminal, for their actions. So it's very important that when you become that power of attorney, you know that you're thinking in their behalf. The benefits and responsibilities of being an agent starts as soon as the principal authorizes it. Most principals, however, don't expect the agent to use his authority until or unless they become incapacitated. So even though you may do a power of attorney that's effective immediately, they're kind of letting you know, well, only when I call you do you need that. There's also another thing called a springing power of attorney that requires the individual, the principal, to be incapacitated. But I'm not going to talk about that here because none of my clients, we never recommend that to our clients, and none of my clients have a springing power of attorney. When you appoint someone, or when you find that you've been appointed as an attorney in fact for someone, it's very important to have a conversation with the principal, the person who appointed you, and to really discuss their expectations to ensure that there's clarity on how to best carry out their wishes. And so just kind of come up with some hypotheticals. Often you've been appointed either because you're a spouse or you're a significant other or you're a very dear friend or relative, a very close relative, but nevertheless, you still want to make sure that you understand what their expectations are when they're making these appointments to you. Now, by the way, if you want to find out more about a springing attorney, we could talk about that. A springing power of attorney, we could talk about that in the Q&A. I also have a article on my website. You can look that up and be able to find more information about it. So, should an agent need to act on behalf of the principal, it's important that you document everything you do. Every time that I've had a client who has accepted a power of attorney and they have to begin using it, or they become a successor trustee, which we'll talk about later, I always tell them, get a little black book. And back when I was in school, they called it a salt and pepper book, the black and white book that you can't pull pages out of. And the reason why I say that is keep that as your ledger. Every dime that you spend, every dime you bring in, I should even say every penny you bring in, every dime you put out, and all the actions that you take, conversations and overviews that you have with the principal, you should document. As an attorney, many of you who are my clients, you've heard me say that my job is to pray for the best and plan for the worst. And so that recommendation is planning for the worst. Should it ever come to pass that your action as a fiduciary is being challenged, by keeping that book, it goes a long way, and we've been very successful by the time people have that documentation to manage them through that litigation. Listen, if at any point in time, one other thing, make sure, keep money separate. The legal term is called commingling. Do not do that. If you're managing someone else's money, keep it in a separate bank account. It could be the same bank as yours, but just a separate identifiable account and trackable account. Do not put, yes, of course it's going to be easy to have it in your own account and be able to have one bank card. You're asking for trouble. Do not commingle the funds. All right. Now, once you find out you're appointed, if you're unsure about any of those, what your duties are, what your responsibilities are, be honest with the person who appointed you. If you don't think you can do the job, tell them. I said, I just don't think I could do it. There's too many family drama that's going on. For whatever reason, just be honest with them and let them know that you do not and cannot accept that appointment. All right. At the same time, if you do accept it, like I said before, ask for clarification about your responsibilities and their expectations. So by arming yourself with the facts about your duties, it'll be much more easy to accomplish the goals and wishes of the principal who appointed you. There are some limitations to with a durable power of attorney. It's not valid in every circumstance. We'll talk about the wills and probate in a minute, but it's important to recognize that aspect of estate plan, that a power of attorney cannot handle everything. Like I said before, they can be very broad, but the IRS, Social Security Administration, and the VA and some financial institutions have their own documents that they need you to complete. It has its own form. It's called a Form 2848. Generally, if you have an accountant or a tax preparer or a tax advisor who deals with the IRS on your behalf, you sign this document. The IRS does recognize that if the person submits a 2848 and attaches the power of attorney that gives them authority to talk to the IRS, then they will accept those two documents. So you don't necessarily have to you don't have to sign the 2848 if you've already signed the power of attorney, but your agent, the person you've appointed, does need to complete it, put all their information on there, attach the power of attorney to it, and the IRS will accept that. Social Security, not so fast, not so good. They require their own document, and it's to be appointed as a representative payee. Again, the circumstances will dictate who has to sign it. If you have capacity, then they'll ask you to come with them to sign the document at Social Security Administration. If not, and there's documentation about your incapacity, then they will allow you not to have to sign it. But the individual who's appointed does have to sign that document. Also, with the Social Security Administration, they will often require you to do an accounting. So if you're managing their Social Security income, their benefits, and you're the appointed representative, they regularly will ask you for an audit. They'll do an audit on you and just say, okay, account for the funds. So remember earlier when I said keeping two separate bank accounts, very, very important. It becomes a lot easier when you can do it that way, and just be able to look at that bank account, see what the transactions are, go back to your salt and pepper book, match them up, reconcile them, and be able to say, okay, here, SSI, Social Security, SSA, here's your equipment, your accounting. Now, the Veterans Administration, same thing. They have their own process, which is a little bit more complicated. In fact, it's a lot more complicated if the individual has not specifically told the VA that you represent them. They have what's called a accredited representative. Generally, those are for attorneys. There are some what I call professional agents. If they're part of some nonprofits that this is their full-time job, they too will be granted that authority on there. But the VA is very clear that the state power of attorney that you created is not sufficient to be a VA representative. So you do have to go through their process, which is there's one for an individual, and there's a separate one for what they call accredited representatives. Those of us who have licenses and have gone through a specific training and this, that, and the other, we have a separate form. And finally, some financial institutions, I call these a pain in the neck institutions, they will they will ask you to complete their document instead of the ones that we prepare for you. You don't have to do that because the laws of the jurisdiction require that they accept those power of attorneys if they are legally sufficient according to the state. Now, while you don't have to do it, it just makes life easier. So if they do ask you to do one, and you have the capacity, then just go ahead and complete that one as well as yours. In situations where you're incapacitated and you are a successor or you're an attorney in fact, then you probably want to call our office to get you some assistance with that, but to make sure that it actually does get filed and they do accept it. So Maryland, DC, and a number of jurisdictions, it is law that these institutions have to accept the power of attorney that is approved by the jurisdiction. So, as I said before, I skipped probate, but that is because your power of attorney dies when you die, right? So if you authorize someone or if you've been authorized to serve as an agent, that authorization dies when the principal dies. I mean, it just the moment you have no more authority over their assets or their person once they're dead. And so therefore that's where the will kicks in. And that's where they appoint or nominate a personal representative that goes through the probate process. So it's very, very important. You have no idea, and I know Brianna's shaking her head, and Angelique, the number of people who call and say, well, I don't need I have the power of attorney, and they're not letting me do this. But that's because that power of attorney is no longer valid. And so don't forget, as the questions come up, please put them in the chat, and we will definitely get to them. Okay, so now let's talk about being a personal representative. Personal representative is when you go through the probate process. And the duties of the personal representative and what we'll talk about later, a successor trustee, are very, very similar. Both of you must collect and manage assets. You must pay debts, and then ultimately distribute the assets to whoever the beneficiaries are. You got to note that the personal representative is only nominated by someone to serve in this role. That nomination needs to be confirmed by the court. So let me just clear that up for a second. When you create your will is really a nominating document. It is a recommendation of what you want to happen. The court, once you pass away, that document is then submitted to the court. It's a petition for administration, and sent it to the court and say, please accept this recommendation from this individual, from the deceased, as their legal instructions as to how to carry out their estate. The court will then look at it to make sure it's valid, that there's nothing in there against public policy, and it's been done according to the law of the jurisdiction. And once they do, then say, okay, use this as the guide for how the estate should be administered. So who's the personal representative? Look to the will, right? Name that person. They now have the authority to carry that out. So it's important to understand, just because it was said in the will doesn't necessarily mean A, that the will is going to be valid, and B, that all the terms are going to be carried out accordingly until the court approves it. And as I said before, we call it personal representative here in this jurisdiction, but around the country and many other places, you'll hear executor or administrator, right? And all of our wills, unless the client has specifically asked otherwise, is to have it done without the court supervision. And when I mean court supervision, it doesn't mean it doesn't have to go to a court to be nominated. It just means that the court doesn't have to track every single detail, and the personal representative doesn't have to put up a bond for the estate. So there's certain periods where they have the authorization to take all the actions, but they still have to account to the state in terms of what they did. So they don't necessarily need approval before doing everything. They just have to make sure account that what is in the will was actually done. So as we talked about, the petition for probate must be filed with the court for the personal representative or executor to be appointed. If you agree to be an executor and no one objects, the court will issue letters of administration. The letters authorize the personal representative to gather the estate's assets, to sell those assets, to pay creditors, and to open up a bank account. The number one duty, the very first duty of a personal representative, is to protect and to preserve the estate assets. So this is always a little bit of a tension. If you know ahead of time that you are the personal representative for someone's estate, and you know that they passed, and now you hear that they passed away, while it's not your obligation, you do have the authority to begin to protect the assets. Okay, so the courts have said you can, for the protection purposes, that can go back to prior to appointment. So if you know that you are in fact the personal representative nominated in the will, and the will exists, you have the will, you can begin to protect the property. So if that means changing locks on the door, making sure that family members are not walking out with suddenly items that she would have wanted me to have, that grandma would have wanted me to have this, mom would have wanted, dad would have wanted me to get this. Whoa, time out. There's a process that's to go through. And you have the authority to be able to shut that down and to be able to protect those assets before they start getting taken. Now, once you've been appointed, you should try to start putting together an inventory of all the assets and their values as of the date of death. Generally, that's done through an appraisal. You have a property appraisal and your personal property appraisal. Um, so the next step is for your personal representative to check the powers that they have over the property in the will. So again, like everything else, it's like the power of attorney. The will gives some people more powers than others, and there's more specific things that they want them to do. For example, they may say, I want the house to go to my children, but I don't. I have 3 children. I want it to go 2/3 to my daughter, and I'm getting myself in math now, and 1/6 each to each of my 2 sons. So rather than splitting equally. So again, it had just terms of what is directing the agent to do. I always advise a personal representative, once you're appointed, consult with an attorney. Just do initial. You may not even have to hire them going forward, but just get a consultation as to, all right, what are my responsibilities? What are the next steps? What does this thing say I'm supposed to be doing? Okay, and it's worth it to pay for it. It's a couple $100. I don't care any attorney you go to, most of them it's going to charge you a couple $100 to do that kind of consultation. And then from there, you decide and said, nope, this is way over my head. I want to hire an attorney to help me do this or to do it for me, or I got this and I can take care of it. So, but it's well worth that investment. And then ultimately, the executor or the personal representative is ultimately responsible for distributing the estate assets to any heirs according to the will or the law, depending if there's a conflict. If there's no will, then like I said, the state defines who they are. But since you're here, they're all wills in play. Okay, and remember, the distribution of estate assets only occur after debts and taxes have been paid and any of the expenses of the administration have been paid, and that includes fees for the personal representative, fees for the attorney, fees for an accountant, any burial fees or any burial costs that need to be reimbursed. Obviously, any taxes that are owed, any outstanding debts. Remember, it's only the debts of the decedent that the estate is supposed to pay. So if they can't pay, they can't come asking you for money that doesn't belong to you. So only pay the debts that belong exclusively and only to the decedent. Okay, so when we talk about paying debts, taxes and expenses, again, look to the documents. The documents will say who's to do what and how it's supposed to be done. Creditors' claims may need to be paid, but just because a creditor has submitted a claim or doesn't necessarily mean it needs to be paid. It depends on how they submit the claim. There are legal manners as to how they're supposed to submit claims. So we always tell our clients, the minute if they hire us, any creditors call, tell them to call your attorney. Don't talk to them. I got an attorney, call the attorney. Because there's legal steps that they have to go through to be able to, quote unquote, file a claim. I mean, to get paid as a claim. And if they fail to do that, then they don't get any money. They don't get paid. And so we always tell the personal representative, don't start writing checks immediately or right out the gate. Don't do that. Just let them follow the process, and then they'll get paid. Because once you paid it, they're not going to give the money back, right? Okay. There may also be certain taxes that have to be paid after death. There may be back taxes that are owed. So the IRS, you've heard the joke that there are 2 things in certain life: death and taxes. Well, the IRS getting theirs is really what they mean when they say taxes. They're going to get it one way or the other. And the challenge with this is, how do you know if they owe taxes or not? Well, often the IRS will send out bills or they'll send out a notice. But once you fill out a form notifying the IRS of death, of the decedent's death, the IRS will then send you, the personal representative, a bill or information letting you know there's outstanding debt. If you fail to pay that or fail to file that form, and then later on, the IRS finds out that there was money that was distributed, they're coming to the personal representative. They can hold the personal representative personally liable for those And then, you then have to try to go back to the people you gave the money out as the personal representative and say, listen, they actually owed money. I need you to give that back to us. Well, depending on how long that period is, that money might not be there to be gotten. So again, I'm not trying, it doesn't have to be me, but any estate planning attorney, that this is what they do, state administration, talk with them, try to work with them. Even if you don't hire them full time, you can do what's called ad hoc, as a certain step. Hey, can you review this for me? Make sure I'm doing what's okay. All right. So, we always recommend that you do that. And then finally, after everything's been paid, is then when you're able to do the distributions, to the beneficiaries. You have disclaimers, you have elections. Disclaimer could be, and we have this right now, a situation where dad died, but the house was only in his name. So there's mom and dad, and dad died, 3 kids. By law, the way the house, the way everything goes, part of the house goes to mom, and the other rest of the house goes to the kids. Well, but that means that mom at this point in time has a problem being able to refi from the house to be able to pay off a lot of the debts. So what the kids have done is they said, listen, and it's both their natural parents. So the kids have disclaimed their inheritance and said, no, we don't want it. Give everything back to the sole heir, which is the mom. And so, well, not to the sole heir, but to his wife, and let mom get her piece. And then, because we know when she passed away, she's leaving everything to us because we're also her children. So that's where disclaimers happen. Some people may not want to do disclaimers because they're getting public assistance and other benefits, and like, nope, I don't want that. That goes to someone else. Keep in mind, however, if someone's supposed to receive something and they have children, by law, if that person passed away, the child would get it. So you have to get disclaimers down the entire line. In this example I just gave, none of them have children, so we only just got their 3 disclaimers. But if they had children, then you have to also get it one step down to what would be effectively the grandchildren of the parent. Okay. All right. Beneficiaries. Now, when it comes to distributions, you have really 3 types. Specific gifts. And again, the will lay all that out. You may say, I want the family Bible to go to my daughter. She's the eldest. You got it because you're the eldest. And so you're leaving it to your eldest child, which is your daughter. So that is a very specific gift that you're saying, when this happens, do this. Before anybody else, do this. You want to make a donation to charity. So take $10,000 and give it off the top to American Cancer Society. Okay? Those are what's referred to as very specific gifts. Irrespective of what's happening in the estate, these are specific things that you want to have happen. Okay. Then you have personal property. You have personal property, which is essentially what happens to, well, let me put it another way. Personal property is everything other than real estate and cash. Okay? So it's jewelry, artworks, collections, furnishings, your car, and any one of you are my clients, we have a rule about a boat. Okay? We have the rule about boats. But it does include personal property is in there regarding boats as well. And so those are also how things are going to be distributed. Some of the personal property is what's called probatable and needs to be put on accounting for probate. Others are not. Clothing, for example, it does not have to be accounted for in terms of probate. All right? It just does not. The court doesn't care how expensive those sneakers were. It's just considered article of clothing, not subject to. However, furs are considered probatable. Okay, so yes, it is a part of clothing, but it's got its own separate caveat. Jewelry is probatable. When I say probatable, it means that you have to you have to inventory it and do an accounting for what happens to it. Okay, but all those things fall under personal property. And last, residuary is just what it means. So after all the specific gifts have been given out, all the personal property has been distributed, all the debts have been paid, all the claims have been satisfied, what's left is the residuary. And then who gets that? and how do they get it is how that would occur. All right. It's also known as the final distribution. And so again, when you do that accounting, you'll see all of that, and that process, there's a process for doing that. Okay, so we have finished with the power of attorney. We've kind of done with the will issue. I see there's a question on there about if there's no will, and I'll come back. I'll answer that at the end. Well, actually, now it's a good time to go ahead and answer that. If there's no will, then all of the actions pretty much remain the same. Whoa, okay, so Siri's listening. They're nosy. If there's no will, the functions and duties remain the same, except that now the state is going to dictate how things are distributed. So there's no specific request on with what we call intestate. Intestate means an individual died without a will. And so depending on their jurisdiction where they lived at the time, their primary residence at the time of death becomes the jurisdiction that manages their estate. That the laws of that state will dictate how things get distributed. So your will supersedes what the laws say in terms of how things get distributed. So if without having a will, the state of Maryland and District of Columbia and the state of Virginia, the Commonwealth of Virginia have already, they have a plan for you, what happens to your state. And so that's what will have to be followed by. In addition, you may also have to do probate, put a bond up, unless all of the potential beneficiaries and debtors say, nope, we're good, we trust, and don't need to put a bond. So you may have to put a bond up. It may be supervised, depending on various circumstances. So we always say it's a lot easier. You still have to go through probate with a will, but it's absolutely easier with a will than without a will. Revocable living trust, also known as the RLT. Those are created during a client's lifetime, during an individual's lifetime, and can be changed at any point in time by the creator, the grantor, until they become incapacitated or when they die. Right? So up until, that's why it's called revocable. You can always make any changes. You can cancel it. You can do whatever you want with it until incapacity or upon death. Right? It's a tool that enables someone to, have this contract with themselves where they become 3 in 1. They're the initial trustee. They're the grantor, because they're the ones who are making it. The initial trustee as the person who's now managing the assets in the trust, and they're also the beneficiary of the whatever assets are in the trust. Right. So an RLT allows individuals to continue enjoying the money and the property as a current beneficiary during their lifetime, and then designate what happens to that money and property upon their incapacitation or upon death. And so, like I said, while they're alive and well, they serve those 3 roles. Right? The successor trustee only comes into play if and when the initial trustee becomes incapacitated or passes away. So as a successor trustee, you have no role while the initial trustee or the grantor / initial trustee is alive, healthy, and well. Your role only begins when they become incapacitated, and we talk about how that's defined, or when they pass away. The one thing you want to do, however, is to make sure talk with that initial trustee. Hey, I see you got the kids here, and we're going to keep you alive for a long time, but something happened to you and your wife tomorrow, or the 2 of you tomorrow. What do you want me to do with the kids? Where do you want me to put them to school? Where do you want them to be raised? What are your plans, your expectation, your vision for the children? Do you have any other obligations that I should know about? Yes, we care for my mom, and she lives in Milwaukee. And Oh, I didn't know that. Okay, so those kind of things, you want to be having those conversations with the person who appointed you and with the person that you appointed, just so they can be ready to take over and not have this gap in care or gap in service with any dependents that you may be dealing with. Okay. For the successor trustee, we're going to kind of go through, because this is This is a weighty responsibility. I'm not going to sugarcoat it. It is a lot of responsibility, and there's a lot involved in it. So I'm going to spend a little bit more time on this topic than I did with the others. All right. So we're going to talk about when it becomes effective, which I just covered briefly before. The duties and responsibilities, the powers, distributing any trust assets, compensation, liability, and what's called self-dealing. All right. First, it becomes effective upon incapacity, death, or when the grantor says so, or / initial trustee says so. So, incapacity, defining incapacity depends on the circumstance of the individual. So often in our documents, if you're married or have a significant, if you're married, under the laws of Maryland and DC, or have a domestic partnership, generally what the document says is your significant other, your partner, and a doctor both verify and say that you have lost capacity. So your spouse, like in my case, in my house, my wife accuses me of being crazy all the time, right? And that I've lost my mind, which on sometimes she's right. I just don't agree. I just don't tell her. However, that's not sufficient enough for her to take over my part of the trust. All right. She has to go get a doctor to agree with her that I've really, really lost my mind. And in most cases, it's going to be my doctor, not a doctor, a friend of hers. So if you're an individual, generally what that says is then it's your doctor and then another independent doctor. Now, that independent doctor can be from the same hospital, same medical institution, medical place. It's just that they're not related to you. They don't treat you regularly. There's an independent assessment that they're verifying, yes, that you have lost capacity to be able to manage your financial affairs on your own. Okay. All right. So that's the first time that it becomes effective. The second one is obviously death. Once you pass away, you become immediately appointed as a successor trustee. There's some paperwork that will want to fill out so you can bring those to different institutions, but your role begins immediately upon incapacity and upon death. Now, there's also the grantor can give you authority at any point in time they want. They can resign. They may say, listen, honey and I are going and we're taking a world cruise and we want you to manage everything. Often, if you'll also hear that people who go into government positions, they put all their assets in trust. Yep, okay, and this now someone else is now managing it for them. So the grantor / the initial trustee can also dictate when that trust occurs. I mean, when your successor trustee responsibility kicks in. Although you now have control over the trust accounts and property, you also have a lot of duties and responsibilities to fulfill. In general, you have a legal duty to administer the trust in solely, as we talked about before, in the interest of the beneficiary. And the beneficiary, again, could be the initial trustee if they're incapacitated. It could be the people that they wanted to leave their assets to. It could also be any dependents that they're saying. So the document's going to dictate who those beneficiaries are. And you must deal with them impartially and without bias. So if you're dealing with the children of the decedent, just because the one of them was a constant pain in your neck, your nephew was a constant pain in the neck, you cannot treat him any differently than you treat the other two. They all have to be treated equally as according to the terms of the trust. Now, if the trust says, okay, that nephew was a pain in the neck to us also, so you give him less or do whatever, then that's fine. But the documents kind of direct that. You also cannot use any of the trust property or the trust accounts for your own benefit or for any purpose not expressly stated in the trust. We'll talk about compensation in a minute. That does not include compensation. You also can't enter into any transaction that would conflict or be a conflict of interest between you and a trust beneficiary. So I run a law firm. I'm a trustee, and someone appoints me as a trustee. I can't hire my law firm to be the trustee or the trust protector, if you will, of a trust that I'm managing. And many of you who have trust, you know what I'm talking about when I say the trust protector. Okay. We can't do that. Because that's a conflict of interest. How am I going to be the one who supervises what I'm doing? So there's a conflict of interest. I'd have to find another firm or another outside trust protector who's independent to be able to do that assessment. All right. The trustees should be informed about the sources of their authority. Always be familiar with the document. Always be paying attention as to what the document says. The first source of authority is always going to be the trust document itself. You get your authority from the trust. All right. Then that trust should be consistent with the laws of that jurisdiction. So there's some laws that are created that the trust can override, and there's some that the trust cannot override. So, for example, under no circumstance can a trust go against public policy when it comes to discrimination based on sex, sexual orientation, religion, ethnicity, et cetera, nationality, et cetera. So you can't say that my son can inherit all my funds so long as he doesn't marry someone of a different color, different nationality, different race. Can't do that. That's against public policy. The law overrides that. On the other hand, the law says that people will put together a bond to be able to manage the trust. The trust says no, they don't need a bond. Okay, well, the trust controls. So you really have to kind of marry the two between what the rights of the authority in the trust are, as well as what the laws say. You are the successor. You have been named as the successor trustee. You do not have a duty to act or to do anything with the trust until you accept the role. So remember earlier I said when they die, your authority begins right then and there. If you accept the role of successor trustee, okay, you don't have to accept it. You can say, nope, let this pass. Let this pass me by. All right, this is not me. I can't do this. I don't want to be involved in this. I don't know why they appointed me. No, not going to do that. Now, once you accept the appointment as trustee, all right, to administer the trust, you have a duty to administer it in good faith in accordance with the terms and purposes and interests of the beneficiary, just like we talked about before, and to be consistent with all the laws that are there. All right. Your obligation cannot be eliminated. Your obligation to properly administer the trust cannot be eliminated or modified by the terms of the trust. All right. And it's an affirmative duty. So what that means is you can breach your duty by not doing something that you were supposed to do. Right. So just because you can't say, well, I didn't do anything. Well, yeah, that's the problem. You have the duty to do something for the beneficiaries, and you didn't. Duty of loyalty. You must administer the trust solely in the interest of the beneficiaries. All right, some of these are going to sound a little bit redundant, but this is where you get in trouble because they all have their own definitions and come after you that way. So it's fundamental obligation of the trustee, and it precludes the trustee from placing his or her interests above the beneficiaries. Duty of impartiality, we talked about that already. So you must, it's very closely related to loyalty, but you must do it for the beneficiaries and treat them all equally and without bias according to the documents. One little caveat to what I just said, because we had this come up not too long ago. The duty of impartiality does not require that all beneficiaries be treated equally, but rather equitably. All right, now what does that mean? Because we hear all that in civil rights areas. Okay, the trust may say all 4 kids in equal shares. Well, that means each one of them get 25%. Okay, and so therefore they're being treated equally, and they're also being treated equitably because that's what the document said to do. But in the document, it also says that should one of them not have graduated from college or turned age 25, nobody gets anything. And the presumption there is that if the parents had been alive, they would have continued paying for the education like they did all the other children before distributing whatever money they had. So you have three kids who graduated from college. If you put them through college, they come back and one says, I want to buy a house. I said, well, I got to get you, your younger sister here has got to get through college also. I don't have the money to do both. So while it may not seem equal because the other three are not getting anything, it is equitable because it's consistent with both the trust documents, but also with the actions of the parent and what they would have done, what they would have done if they were here. So if there's ever any, again, if there's the caveat to all of this, if there's ever any questions, consult with a lawyer to get some details on it. Prudent administration. The courts, the exact definition of prudence varies all over the place. So it really depends on whatever the statute and the case laws of your jurisdiction say. But essentially, it requires you to just follow the terms of the trust, and where there's ambiguity, what would a prudent person do? Back in law school, we always had this reasonable person test, and you say, okay, who's a reasonable person that they're basing it on? Because you just don't know. But that's what they talk about. What would a reasonable person or a prudent person do in a similar situation? And that's always going to be, fact based. That's going to be a circumstance by circumstance. There may be economic climate, or the COVID may be going through, which is something we've never had to deal with before, at least not in our lifetimes. And so circumstance change. And so what would a reasonable person do in that circumstance? Okay. All right. Making sure it's a duty for record keeping and identification of trust property. We talked about that already. You got to make sure. You must make sure that you track those the assets, including the cash. Just please make sure account for all of that. To control and protect property, we talked about that in the beginning. So once you get appointed, you got to figure out what you have. What are you now responsible for? Because you go back to that duty of administration, you fail to do that, that's considered a breach of duty to administer, because you didn't do the homework to go find out what assets belong to the trustee, to the trust maker, to the person who granted you this authority. So you want to go and make sure that you're able to identify those and then protect them and control and make sure they're under your control. Enforce and defend claims. If your trust has a claim against someone and they owe them money, and it's for the benefit, again, for the benefit of the estate and the beneficiaries, go after it. Go get that money, so long as it makes sense. So remember, these things don't all operate in isolation. You have the duty of prudence, but then you also have the duty to enforce. If it's going to cost you $10,000 to litigate a matter that's only going to get you $1,000, it makes absolutely no sense. It makes no sense at all. So you write a couple letters, make a couple phone calls, and when you find out this is going to end up in litigation, no, it does not make sense to go spend $5,000-$10,000 to go get $1,000. It just doesn't make any sense. All right. So these all kind of work in hand. Same thing against defending against claims. If someone's making a claim against the estate, don't just say, okay, all right, here's your check. No, they have to demonstrate that this is a valid claim, and that the estate does actually owe it to them. And once they've done that, what would a reasonable prudent do while they're administering the trust? They would go ahead and write the check to them, so long as the assets are available. Same thing about collecting assets. We talked about with making a claim, collecting assets, same thing. Duty to report and inform. Okay. A trustee has an obligation to keep the beneficiaries reasonably informed about the administration of the trust, as well as any material facts that they need to protect their own interests. Typically, a trustee must notify beneficiary within 60 days of accepting the trusteeship. So you're letting them know that you are now the trustee, and you have to send them the contact information, your name, address, how to get in contact with you. You also have to notify the beneficiaries. So once you accept the appointment, you now have to notify the beneficiaries of the existence of the trust. All right. Who created the trust and what their rights are as a beneficiary. And this typically needs to be done 60 days after the trust becomes irrevocable. And the trust becomes irrevocable, as a reminder, upon the death or incapacity of the grant maker, the person who made the trust. If the beneficiary requests it, the trustee must provide a complete copy of the trust document. Our documents don't require them to do so. I always say, just go ahead and give it to them, because transparency and holding back information is always what starts to cause doubts and questions and distrust. So give it to them. There's nothing to hide. I mean, it's a document you're going to be working off of. Just go ahead and give it to them, or bring them in and go over it with them. But saying no and I can't show it to you, it really starts to get suspicious people even more suspicious. Once they see the document, okay, there's nothing here. We had a client where something happened with mom and dad, life insurance policy expired, and his kids, it was a blended family, his kids got nothing. His wife got everything. And because initially he intended the kids to get the money through a life insurance policy. The life insurance policy lapsed. It was never renewed, so there was nothing for the kids. He didn't update the trust. So the kids were mad at mom. They thought she was lying, et cetera, or stepmom. And so they wanted to see the trust. I advised my client, I said, give it to them. Show it I'll highlight the parts for them to see it. Once they saw that, it was over. It was over. They were mad at their dad, but they were no longer mad at stepmom and didn't think that stepmom was trying to get around them. All right. The other thing is you need to support, at a minimum, you need to provide an annual report about what's going on with the trust. All right. Generally, you want to support that with bank statements, if it's at all possible, any receipts on there. But you definitely want to keep them informed, and you need to do it at least once a year. If the if the trust is filing tax returns, that's also a good document to give them. Here's the tax return for the trust, because the tax return captures all the assets, and this is what's gained or what's been lost in the trust. You have the power to review the trust and authority, of course, which I really want you to do, because that's where you're going to find what powers and authority you have. So you definitely want to review that. Often our clients will give their trustee, because they are very close individuals to them, they will give them discretionary authority in their actions. But again, remember, the trust cannot override the duty of prudence. So you can use your own discretion, but it needs to be prudent. All right? Yeah. Okay. The trust said I can do what I want to do. Yes. Okay. Now, was it prudent for you to do that? And did you treat everyone fairly or equitably in your decision making? So you have a choice between you have a limited amount of money. One child or one of the beneficiaries wants to open up a business. The other one got laid off due to COVID, got sick, has outstanding medical bills, and is unable to pay their rent. Well, you have the discretion as to where you're going to put that limited amount of money. The one would argue that opening up the business does not rise to the level of putting a roof over someone's head and making sure they get their health care. So you have the discretion, it's reasonable, and it passes the equitable test, or I should say prudent, it passes the equitable test. Okay. So again, those are the kind of things you look on there, even though we're saying you're discretionary. And then finally, all of the other duties that we had there, or any power you have, falls underneath those duties. So we refer to those as the fiduciary duties. Okay. The line that I often use, and I see back here when I'm talking to successor trustees, is from a line from Jurassic Park. Just remember that just because you can doesn't necessarily mean you should. Okay. You got to have good judgment. So even though the document may say, yes, you can do this, it may not be in the best interest of everybody for you to do that. Okay, compensation. Again, look to the document. Look at the trust document. Are you required to be compensated? Is it discretionary that you be compensated? So, sometimes they may say, the trustee, again, you must comply with the duty of impartiality in making distributions. So you want to make sure that, I'm sorry, this is not compensation, this is distribution. I apologize. I'm not even looking at the slides. I'm trying to go from memory. So what is the required distribution? What is the required distribution? The trust document will tell you that. All right. How much are you supposed to give? Discretionary now, that we talked about that previously. You have the ability to take care of someone's, help them start a business, help them start a house, or get a down payment for a house, pay for a wedding. Well, remember, you have to be in the mindset of the people you're representing or the person you're representing. So, daughter comes to you and says, well, fiance and I getting married. We want to get this $200,000 wedding. We can only come with $50,000, so we're asking you to pay $150 from our trust. Okay, Paris Hilton, not a problem. However, you have to look at your client and say, would your client say, have you lost your ever-loving mind? Or would they say, yeah, we got enough. Yeah, we would absolutely spend $150,000 on our daughter's wedding. You have to know the person who appointed you. You have to know what their expectations are. And of course, the assets have to be there. All right. So it's discretionary, but you also have to be able to know what would have been done and is it reasonable. And then generally you have the final distributions where we talked about, where we just kind of give the money at the end of the trust and it terminates the trust. So if the trust says we're going to give the fund, after our passing and everything has been paid and settled, give it to the beneficiaries outright. That's it. You give it to them outright. The trust is then dissolved because it is no longer economically sufficient, and it would close out the trust. And so it's all done. Okay. For compensation, this is what I was talking about before. Look to the trust. See what the trust says. Generally, the state in Maryland and DC, they use a reasonableness test. A lot of jurisdictions use a reasonable test. Generally ranges between 1% and 3% of the annual value of the trust is what the compensation level is. So that's why often banks, if they're going to serve as trustees, they're talking about, seven-figure trust accounts, because that way they make some reasonable money. They're not going to be mad. They're not spending their time on a $50,000 trust. In fact, we wouldn't even keep a $50,000 trust open. Once you get over the seven figures, banks start to do that because 1% of that, you're talking about $10,000 annually for the institution or for yourself for the work that you're going to be doing. So that's generally the range, the accepted range. Some jurisdictions go as high as 6%. Around here is generally 1% to 3%. And again, it depends on how complicated the trust and the circumstances are. If you're an attorney and it's being administered in, I'm just going to make it up, Wyoming, and it's 6% there, then that's fine. And you are actually doing all of the work. You are, the regular trustee has deferred everything to you. And the property is in multiple jurisdictions, not just Wyoming. It's also in Nevada and Virginia and Florida. You got a lot of work there. Okay. So those are all the different criteria that go into making it reasonable. You just have to defend it, right? You just have to be able to defend it. Is it something, is that fee, prudent based on the circumstances, of the trust? You, as the trustee or successor trustee, are not the guarantor of any of the assets in the trust. You are not liable for any losses that occur if you have done and acted faithfully and consistent with the documented duties. Okay? If you act within reasonable reliance on the terms of the document, you're not liable to the beneficiaries for a breach of trust if you resulted on the line. So if you did something according to the terms of the trust and the beneficiaries try to say, well, it's a breach of duty to me, or breach of trust or breach of loyalty, so no, the trust document said for me to do that. I relied on that trust document which told me to do that. All right. Now, if you commit a breach of trust that results in a loss to the trust, then you can, in fact, be held personally liable. Okay. You can also be held liable or accountable for any profit made by you, the trustee, during your administration, if you had a conflict of interest. So you did something and you invested in, use a trust to invest in a project you were working on, and then you made a whole bunch of money from it. You can actually be obligated to put that money back into the trust. So you have to be careful. You have to be very careful on that. And then, of course, everything you do must be in good faith, with the beneficiary, the best interest of the beneficiaries in your mind, and with the best intentions in mind. And of course, you have to comply with all the fiduciary duties. So essentially, self-dealing is what I said earlier before. You want to, you're now the named trustee, you're the trustee, you're also the beneficiary. And you want to sell the property, there's a property and you want to buy it. The market rate for it is, $500,000, but you want to buy it for $400,000. That's self-dealing because you're giving yourself $100,000 break. So you can't do that. However, who's going to challenge you? Because you're the sole beneficiary. So often when we have successor trustees who are also the sole beneficiary from a family, we allow them to do the self-dealing. I mean, why make them go through all of the hoops and hassles and craziness when they're the ones who are going to be getting it anyway? So if they decide to squander the money, they're squandering their own money. So if they decide to invest it and do things with it, it's their money. So the self-dealing really depends on ultimately what the role of the trustee is as it compares to the ultimate beneficiaries. All right. Always make sure that you adhere to the language of the trust. All right. There's not always a clear-cut answer in the trust. So sometimes, again, you have to go back to just using good judgment, making sure that you are doing what you think is, if it was an ordinary person, is this what they were doing? Would this pass the smell test? And again, you can do it if the document says you can do it. You can also do it if the beneficiaries say it's okay. So again, if you are the beneficiary, you're giving yourself authority to self-deal. If it's you and your siblings, and the siblings say, yeah, you've lived in that house, and I know they wanted you to have that, go ahead and just buy the house. We're fine. We don't need the money. You can sell it for less. Then that's great. I want those siblings, by the way. But if the other beneficiaries consent to you doing the self-dealing, then that's fine. And finally, there could also be requiring to go to the court. So if you believe the self-dealing is in the best interest of the estate or of yourself, you can go to court to get permission to be able to do those actions. Okay. So that kind of covers the high level roles of what to do once you get appointed, what your responsibilities are. I hope this information has been helpful. And like I said, this is not the end all and be all. In fact, if you still have a great deal, you may still have a bunch of questions, which we're going to answer in a minute. But then you also, if you have those questions that are specific to you or to your circumstance, as a successor trustee or appointed power of attorney or anything on that line, you can actually contact us. And by the way, for those of you who may not have gotten the announcement, our office has changed. We're in the same building. We're just downstairs. So rather than moving on up to the east side, we moved on down to a much more comfortable, cozy environment. I really like it. And so we're down in Suite 205, as you'll see. But yeah, if you scan that QR code or you just call the office, you can schedule a 30-minute fiduciary meeting. That's one of the rewards for you coming on this call. Did I not say we're in Suite 205? I might have misspoke that. Anyway, we're in Suite 205. But you can scan that, and we'll do a virtual one-on-one with you, just to kind of go over your specific questions regarding your plan. Now, also, if you've not prepared your own estate plan, you can also click that link to schedule a discovery session as well. So we can kill two birds with one stone. So I want to thank you for your time and attention, and I'm going to try to answer some of the questions going forward. Interesting. So this question regarding a trust and a will. If you go to any professional estate planning attorney, you're always going to have a will and a trust. And there's a reason for that. When you have a trust, as you know, if you did a trust with us, and you had a real property, house, residence, we take your house and we put it into the trust. We also give you funding instructions on how to go about funding and putting the rest of your assets into the trust. But there may be a point in time where you either didn't get to that soon enough, or you bought another property, or something happened to where you became incapacitated or you died without being able to put that asset into the trust. Well, actually, if you became incapacitated, that's not a big deal because your power of attorney will be able to help them do that. But if you died without having put the assets in the trust, it's too late at that point. Because remember, as soon as you die, the trust becomes irrevocable. The assets are now outside of the trust and they're now probatable. So what the will does, and we call it a pour over will, like you're pouring water out of a pitcher, it says, listen, I know these assets have to go through probate, but instead of distributing them anywhere, they go to the trust. Okay. And then the trust will handle all of the necessary distributions. So you really need to have a will and a trust, because there will, in the event that you have assets that are not in the trust when you die, if you don't have a will, then they're going to follow the terms of the jurisdiction, whatever their laws are, and who gets what, how much, when, and all that kind of stuff. So any professional estate planning attorney worth that you paid money to should give you a trust and a pour over will at the same time. Right? They just need to be done at the same time. Okay. Do the laws that bind the trustees in the estate the grantor or the trustee? Great question. The laws that bind the trust are in the trust. So if the trust was created in Virginia, then typically it's the Virginia law that creates that binds the trust initially. But depending on the trust that's written, if it's our trust that's written, it allows the successor trustee to relocate the jurisdiction of the trust, okay, upon the passing of the initial trustees. And the reason why we do that is Maryland, Virginia, not so bad, but you have some clients where the successor trustee lives out in Montana. Well, why should they have to get a Maryland attorney who they don't know to work with them if they may know someone in Montana and, they're much more familiar with what's going on in Montana, move it over to Montana and allow them to administer it that way. So long as Montana doesn't make it any worse for the beneficiaries, right? So remember, you can't have a conflict of interest. If you're moving it to Montana for your convenience, but it's the detriment of the beneficiaries, then you should keep it, right? Because the beneficiaries come back and be able to say, you didn't have a duty of loyalty. You breached your duty of loyalty to us, all right? So if there's no effect on the beneficiaries, go ahead and change it. Our documents give them the authority to do so. I hope I answered that question. So the annual report of the trustee annual report generally goes to the beneficiaries. All right. So you would keep it in your records, and then you would just give it to whoever the beneficiaries are. Again, as to have them. And so I'm talking about the annual report that you do. And if you had a tax return, you'd give them a copy of the tax return. If you do your own accounting, and it can be in any format. I do the real KISS principle. Like, this is what we began the year at. This is what the expenditures were. This is what the income was. This is the bottom line. Have a good life, or a good next year. And then it does not have to be terribly complicated. It can be as simple as possible, just showing in, out, and what's left. All right. Yes. So one of the great benefits of doing a revocable living trust and having it fully funded is that you never have to even look at the probate office. Right? You don't have to see them. You can just drive right on by. If you're playing Monopoly, consider jail. Just skip jail and just go. You don't have to worry about that. Now, the key that I said there is fully funded. I have some podcasts and I have some blogs about that, about what it means to fund your trust. You got the instructions. I'm going to start following up with all of you intentionally to see where we are on that. And it's not just so I say that, but remember, for all of you who created a trust, we didn't put your car in the trust. We gave you a beneficiary form, an MVA beneficiary form for you to complete. we have a client who unfortunately, they thought the car was jointly owned. It turned out it was owned by one spouse who passed away. And now we have to open up probate just for, they have a trust. Everything else is in the trust or jointly owned, but we have to open up probate just for the car. We really don't want to, I mean, things like that, we try to avoid those as much as possible. So we give you the form, both Maryland and DC, you can complete that form. And so that's one of the things that we're taking upon ourselves, as we start the new year. And we're going to start annoying you, about doing that. So you've been forewarned. You're going to be annoyed, as to whether or not. And, as a friend of mine at one point said, trust in God, get everything else in writing. We're going to need to see documentation, that everything is done, because we're doing that for your interest and your benefit. Okay. All right. Any other questions? I think all the questions on here have been answered. If there's a question that you're still confused about the answers that were given, by all means, send the question again. Well, I want to thank you. I think that's it. I don't see any new questions coming in. I really want to thank all of you for joining. And so remember, we do this twice a year. And so now that you've gotten some of your update and introductions, I see who some of the participants are. Remember to invite the people who you appoint, in those positions. So our next one, I don't have the exact, oh no, the next one is actually Saturday, March 22nd, 2025. You'll get an invite, about that. But it's already scheduled. We do twice a year, once in March, once in October. And we just do it the same way. So it's really helpful, that you're here and you have a better understanding as to with your successor representative, but also, you can invite them next time, to listen in, and so they understand what to do should the terms, come up, for them to serve. Angelique, Brianna, do either one of you have anything that you want to add or say?
No, I do not. Thank you guys so much for attending and spending your Saturday morning with us.
Okay, thank you. Okay, so there is one other question on here. How can you confirm that an LLC is in the trust? Well, a couple of things. One, you need to have the documentation. There should be, an assignment of interest, document that's there. Generally, for example, we give you a binder, and there's a section, and Brianna will be able to talk about all that. That's the last person you see when you do our documents. But in the back, there's a section for other documents and important papers. And so you would put that in there. There's also an asset section. And so you could put the assignment of interest, there. So look and see if that exists. But also, please remember, and you guys heard me have this conversation, the trust doesn't fully control. It says what you want to have happen. The LLC must have an operating agreement that accepts the replacement of the interest by a third party, meaning the trust. So if the LLC does not have an operating agreement, the trust is pretty much not going to be able to serve any purpose. So the two have to work hand in hand with each other. There must be an operating agreement, when you're creating that trust. Okay. Thank you guys. And again, this is going to be recorded. This is recorded. And so, we will clean it up and get it all out to you. The slides, I don't circulate the slides, but I will, because they don't have really a bunch of information in there. But I do have the recording, which will, be able to explain everything that I said. You can turn that on and, instead of calm and all those other things, and get great sleep listening to me go over this all over again. Mm-hmm. Thank you. Enjoy the rest of your day and have a great weekend. Talk to you all soon.